Hello, friends, and welcome to the Aspen Ideas Festival Supreme Court panel. The Supreme Court, as always, has checked in with the organizers of the Aspen Ideas Festival and has thoughtfully handed down its affirmative action decision moments before we convene. And we are here to discuss the momentous decisions that the court has handed down in the past few weeks, including affirmative action, the future of American elections, the future of the Voting Rights Act, and much more. We have a remarkable panel of America's leading Supreme Court thinkers and litigators. They have a diversity of views, and our goal is both to help you understand the legal reasoning of the decision and their implications, both the majority opinions and the dissents, so that you can make up your own mind. So we're going to jump right into it. I am thrilled to introduce, first of all, Neil Katyal of Georgetown Law School, Hogan Lovells, one of the leading Supreme Court litigators who has just won the independent state legislature case. As those of you who have been to this panel before know that Neil is my brother-in-law, and this is the latest installment of our roadshow, Brothers-in-Law. Next to Neil, we are thrilled to welcome Pam Karlan of Stanford Law School. Pam is one of the leading constitutional thinkers of America, and it's so great to welcome her to Aspen, and also to welcome Clark Neily of the Cato Institute, a leading thinker, and it will be great to have his perspective. Let's jump right in with the affirmative action decision. The court, by a 6-3 vote, has held that the affirmative action programs of Harvard and the University of North Carolina violate the Equal Protection Clause. The court repudiated the holdings of the Bakke and Grutter cases, which had held that educational diversity is a compelling interest. And the court said that the only way to justify racial classifications under the Equal Protection Clause are to show that you're remedying identifiable race discrimination in the past, or you're avoiding an emergency in the future. And because educational diversity is neither of those things, it can no longer be considered a compelling interest. Clark, why don't you lead us off? Describe the majority opinion's reasoning, and also that of those of the concurring justices who argue that the Equal Protection Clause is colorblind. What did the majority hold, and do you agree with it?
I sympathize, kid. This is a really tough.
It was my introduction that meant very sensible response, but
this is a tough decision to make sense of. Even there's a disagreement between the Chief Justice who wrote the majority opinion and Justice Thomas who wrote a concurrence about whether they did or didn't overrule prior precedent, including particularly the Grutter case from University of Michigan on the question of whether achieving diversity on campus is a sufficiently compelling governmental interest. So it's really going to require a deep dive on these lengthy opinions. I forget what the page count is.
239.
239. I knew Pam would know for sure. It's a lot to digest, and I'm just going to be really honest with you. I haven't had time, but I think I can still, sort of try to hit the highlights. And what it comes down to is this. I think there are three questions that these cases present. The first is whether it's ever permissible to use race in deciding whether to admit a student to either a public university like the University of North Carolina or a private university that receives federal funds under Title VI, that is controlled by Title VI of the '64 Civil Rights Act. And Harvard does take federal money. So while the Constitution doesn't forbid Harvard from using race, the argument is that as a recipient of federal funds, they have a statutory obligation to essentially be colorblind, or at least to stay within the parameters of however much race the Supreme Court says a university is allowed to use. So that's the first question: can you take race into account? Second question is, if so, to what extent? The argument that Harvard made in court essentially was, look, it's a small part of their decision. We have a holistic approach. We take into consideration a tremendous number of factors, and race is really just one of those. And then third is a more practical question, namely, what is the university really doing. And there was actually a lengthy trial, a bench trial, meaning a trial in front of a judge in the Harvard case that produced a significant body of evidence that was not prior to that, had not been made public, about how Harvard's admission process actually worked. And one of the most difficult things, I think, for Harvard to sort of contextualize, I was about to say run away from, but I don't want to be pejorative yet, was that the admissions policy at Harvard had a significant impact on applicants of Asian descent. My wife is half Japanese. My kids, therefore, are quarter Japanese, and so this is something, an issue of particular concern in my household. And there was, I think, rather compelling empirical evidence that Asian students had to perform substantially better across a whole variety of measures in order to have a chance of being admitted to Harvard. There was further evidence that if Harvard had a strictly kind of colorblind approach to admissions, that something like 46% of the student body at Harvard would be Asian. And the idea that even if, for example, we say that it's permissible for a university to take race into account, perhaps even to try to remedy past discrimination, which is something that featured heavily in both Justice Sotomayor's and Justice Jackson's dissents, what this case, to me at least, brought forth was that that's not always cost-free. And so if one group is going to receive a preference, which Harvard clearly was doing for African Americans and people of Hispanic descent, then other ethnicities may end up getting short shrift. And it's pretty clear at Harvard that Asians were, in fact, getting short shrift. And so those are really the three questions that I think are in play in this case. Can a public or publicly funded academic institution take race into account? If so, to what extent? And then third, what are they really doing? Put aside what they say they're doing, what are they really doing? Going forward, I think it's clear that universities will be able to continue to take race into account to some extent. Chief Justice Roberts was very clear that applicants will be able to write about their experience in their essays, for example, what it has meant to me to be a member, not me, but what it has meant to a hypothetical applicant to be a member of a particular ethnicity, what hurdles have you had to overcome as a result, and that would be a permissible way going forward for universities to take race into consideration to at least some extent. The devil is really, I think, going to be in the details in terms of how the schools respond and what the courts say about how they've responded.
Thank you so much for setting up so well. Pam, there is a practical question about how race can be used moving forward. And as Clark said, Chief Justice Roberts observed that universities can continue to encourage students to write about race on their essays as long as they tie that to particular challenges or adversity that they've overcome. And there was one other exception saying that the military could continue to take race into account. In practice, what do you think the effect of the decision will be, and how will affirmative action be changed at universities?
So I should say that I'm speaking here in my personal capacity because when I was at the Department of Justice in the Civil Rights Division, I worked on DOJ's amicus brief in the Harvard and North Carolina cases. I think, an affirmative action program done right can survive the Chief Justice's opinion, because what he says there is that rather than just looking at whether someone checked a box saying that he was Latino or she was African American, you should look at how the person explains how their race goes to the qualities that make them an attractive applicant for the school. And I'll just say parenthetically along the lines of something that Clark said, as somebody who has always tested extraordinarily well, test scores are not everything in deciding whom to let in. At Stanford, we reject a number of people with much higher test scores than the people we let in part because we are looking for a well-rounded class of people who've done interesting things, and test scores are not everything. So that means that schools will have to look more carefully. And the one concern that I have about this in the short run is for students who are upper middle class, or who have gotten scholarships to go to excellent private schools or the like, they will have guidance counselors who will be able to tell them how to write the kind of essay that will talk about their experiences in a way that will help to make them an attractive applicant. For students who are going to underfunded public schools in the middle of nowhere with a ratio of students to guidance counselors of 400 or 600 to 1, they are not going to understand how this new process works. And so they are less likely to write the kinds of essays that will make them attractive candidates under this kind of new regime. So that's the first piece of this. The second thing to look at, though, is there are cases coming down the pike that the court didn't address in its opinion today that are worth understanding. And the next one up, I think, is going to be the Thomas Jefferson case. For those of you who are not from the Washington, D.C. area, but are from the New York area, Thomas Jefferson is the Bronx Science of the D.C. metro area. It's a school. It's a math and science high school. It's incredibly selective. It's a public school, and they changed their admissions policies recently to get rid of a test that had a huge disparate impact on Black and Latino applicants, and to use a race-blind process. And that race-blind process has been challenged because the reason they adopted it was to increase the diversity, racial diversity in the school. And if that case goes to the Supreme Court and is decided, then we're in a very different, I think, very different world going forward, talking about what schools can do to make their classrooms diverse.
I'm so glad you flagged that crucially important case for our audience. And as Pam Karlan suggests, the big question moving forward is whether any race consciousness is unconstitutional and a violation of federal law, even if it results in the adoption of facially neutral policies. Neil, help us think through the really important litigation on the horizon. Pam suggested a gap between the majority opinion and that of Justices Thomas and Gorsuch. Justice Gorsuch essentially suggested that the text of Title VI and Title VII of federal law require total colorblindness. If his view got a majority, would that mean that any race-conscious corporate recruiting would violate federal law? And what kind of division do you see among the justices on this crucial question of how much race consciousness is permissible moving forward?
Thank you. It's so great to be here with all of you again. I think I've done this now for about 8 or 9 years, and I love being here, and I love this audience, so thank you. I, like Pam, am speaking personally. I represent, like, everyone in this space, so I'm really very much talking personally here. My reaction to the affirmative action decisions is that they were not nearly as bad as I thought they would be, that they left a lot of room open. So Pam isolates one important thing. The last 2 paragraphs of the Chief Justice's opinion say if an applicant self-identifies on the basis of race and explains why her experience matters and what she will bring to the university, that's okay. Well, that's what, at least a well-constructed affirmative action program will be able to do. Pam's 100% right that this is going to benefit, people who have more sophisticated counseling. I mean, it's kind of like how Donald Trump was good for lawyers. The Supreme Court's good for guidance counselors. And that does really concern me. But nonetheless, I do think it's possible for universities to maintain a diversity-based program that's well crafted. And I think the military exception, the language about that helps as well. There's this really hard question, which Pam is flagging, which all universities are thinking about now, which is, what if we do something that's a proxy for affirmative action in a race-conscious program? So say we look at Pell Grants and, or some sort of socioeconomic status. And will that be challenged as just doing affirmative action through the back door? Absolutely, it's going to be challenged. This opinion doesn't give us very much guidance on it. Pam's again 100% right that the Thomas Jefferson case would, but I don't anticipate the Supreme Court to take another case in this space for a little while. Typically, when the Supreme Court decides a case, then the other cases that raise similar or even adjacent issues, they just throw back to the lower courts for additional percolation. And here, not only did they decide a big case, they overruled or semi-overruled or partially overruled or whatever you want to call it, Mr. Chief Justice, the old cases of Grutter and Bakke. And so I do expect a lot of this litigation to return to the lower courts. So there will be fights at the K through 12 level. There'll be fights in the universities. And my last point, as Jeff said, is there will be fights in the corporate setting as well. That is, this decision has implications for how corporations think about their DEI programs, their commitments to affirmative action and the like. The Supreme Court in 2 cases, Johnson and Weber, said that those programs exist on a somewhat different footing. They're not diversity-based affirmative action. They're designed to compensate for past wrongs. And so there are strong arguments for why corporations can still continue to do this, but Justice Gorsuch flagged the argument on the other side.
Great. Well, thank you for introducing the crucial questions that the affirmative action cases opens up. I do want to encourage you to read the opinions, the majority opinion, the concurrences, and the dissents. This is part of your education as citizens, and you'll see a remarkable constitutional debate between Justice Thomas and Justice Jackson about the history of colorblindness from the Civil War to the present, the meaning of the efforts to achieve racial equality, and whether or not efforts to help recently freed, enslaved men and women should lead to a colorblindness requirement or not. It's well worth reading, and I hope you'll do that. Let's turn now to the independent state legislature case. And since I'm not objective about this, I'm going to quote from the remarkable tweet and tribute from Judge Michael Ludig, who said the following about Neal's victory in that case. And I need my constitutional reading glasses to read it. He said it would be impossible to overstate the enormity of yesterday's seminal decision in Moore v. Harper. Not only is it now the single most important constitutional case for American democracy since the nation's founding almost 250 years ago, it is also now one of the most important constitutional cases for representative government in America. Congratulations on that, Neal. And why does Judge Ludig think that this is the most important constitutional case for American democracy since the founding?
Well, I think it was such a privilege to do this case because basically what the Republican Party was saying was that elections would be governed by the raw political power in state legislatures. The state legislatures can do whatever they want. This theory was used, it was the basis of Trump's 2020 theories about the elections. You might recall that there were about 62 decisions that were going on in the 2020 election. Many of them were in state courts, and John Eastman and Trump's advisors all said these state court decisions are illegitimate. They considered they were about everything from, absentee ballots and, polling hours, all sorts of things, how you count ballots, all sorts of things. This case came from North Carolina, and it was about gerrymandering. And basically, the North Carolina state legislature, North Carolina is a very evenly divided state, has 14 congressional seats. The North Carolina legislature, which is overwhelmingly Republican, gerrymandered it so it was about 10-4 or 11-3 in favor of Republicans. That went to the North Carolina Supreme Court. The North Carolina Supreme Court said this violates our own state constitution, leading the Republicans to go to the U.S. Supreme Court and say, oh, state courts have no business in federal elections. State constitutions have no business in federal elections. And the reason why I think Judge Ludig is saying that is because we found that so contrary to the tradition of checks and balances in this country, going all the way back to the Articles of Confederation. Courts have always played a role, and state constitutions have always played a role in governing federal elections.
Clark, help us understand the argument of the three dissenters. Justice Thomas, Justice Gorsuch, and Justice Alito partially joined them. And essentially, they said that it all turns on the meaning of the word legislature. And since a legislature, in its ordinary meaning, only means a legislature and not the state courts that review the legislative acts, therefore state courts had no role to play. And essentially they said that all of the precedent and history and tradition and practice from the time of the founding until today that suggests that state courts were expected to review the acts of legislatures should be ignored because the meaning of the word is clear. Do I have that right? And try to help us understand their argument.
Yeah, I think you have it right. I'm trying to pick my words carefully here, but I guess I'll just throw caution to the wind since I'm the libertarian on the panel and I know what's expected of me. I think this is such a stupid question that I'm amazed the Supreme Court had to get involved, right? It's like, if I have to stop this car and deal with you kids in the back seat. I think it flows from this ridiculous kind of hypertextualism that we sometimes see. And I'll give you an example. The 16th Amendment says that Congress shall have the power to lay and collect taxes on incomes. And the argument in the North Carolina case strikes me as if somebody said, oh, well, the 16th Amendment says Congress shall have the power to lay and collect taxes. So the IRS can't collect taxes, it has to be Congress. That is a preposterous hypertextualism that's I think, unhelpful and unworthy. And to me, that's a spirit that animates this dissenting opinion, animates the arguments that were made below in the North Carolina case. Another example on the other side would be, the Second Amendment says that the right of people to keep and bear arms shall not be infringed. Putting aside the militia clause, are we really going to interpret the word arms to be every single thing that is an arm, including nuclear weapons? No, that's preposterous. But that would be the kind of hypertextualism that I think is both unhelpful and unworthy of such an important document. And I think it belittles a document to approach it in that way and to sort of fail to keep perspective that this is first and foremost a framework for government, a framework for a particular kind of government, liberal government and rule of law government. And that's the spirit that, in my judgment, prevailed, that animated Neil's arguments and that prevailed in the Supreme Court. And any other result, I think, would have made, frankly, a kind of a mockery of what is very clearly the spirit of this document.
Wow. Significant words from you, Clark Neily. You are one of the leading Second Amendment defenders in this country. You've won some of the major Second Amendment cases. And to learn that you're not a fan of that hypertextualism, to put it mildly, is notable. Pam, help us understand the significance of this debate. And I should say that the three of us are going to have an advanced credit seminar tomorrow morning about how to interpret the Constitution, where we'll dive into these questions of differences among originalists, textualists, pragmatists, and so forth. But there's a big divide, to put it mildly, between the, let's call them traditional originalists, including Justice Kavanaugh and now Justice Barrett in Neil's case, as well as the Chief Justice, and Justices Gorsuch and Thomas and Alito. And the hypertextualists, as Clark described them, would have denied courts any role to play in reviewing elections, as well as requiring a degree of colorblindness that's far more extreme than the more traditional originalists. So help us understand the nature of the debate and what are the consequences of this hypertextualism moving forward.
Sure. Can I just back up 1 minute, though, and say a little bit about one of the big pieces of significance about Neil's case here, and that is the Supreme Court of the United States took itself out of the business of policing political fairness in gerrymandering cases in the Rucho case a couple of years ago. And so the only place you could go to claim that there was unfairness in the way the state legislature draws congressional districts or draws state legislative districts or the way your city council districts are being drawn is to go to the state courts. And the court said there, go to the state courts. And then to turn around and say, but the state courts can't do anything either, was deeply problematic. So that's the first big thing I think to note here. Second big thing to note is what the Supreme Court has done here, and this is, I think, Chief Justice Roberts at his most clever institutionalist in some ways, is he has not taken the U.S. Supreme Court out of the business of policing what state Supreme Courts do. He's left open the question of when has a state court gone beyond traditional judicial review and really started to impose its own notions of fairness. So it'll be really interesting to see how that plays out. Now, what you're seeing, I think, in a lot of the cases in front of the Supreme Court, and I think this may be what you're getting at in part, Jeff, is there are justices who are institutionalists and who are thinking about, in the long term, what's best for the court to kind of retain its power and to retain its central position. And Chief Justice Roberts is an example of this. And then there are what Leah Littman's referring to as the you only live once justices, the YOLO court justices, who are grabbing for as much right now, given how these arguments play out right now. And that's what I think is going on with the independent state legislature doctrine, that, as Neil says, it started out as something that was far cleverer than it was wise, far more textual than it was contextual. And as a result, it looked like something that would be good for one side in the political debates now. And I think that's what drove the justices to that position. I would have been very surprised if they had adopted the kind of independent state legislature doctrine in the way they did in a case where it was going to advantage the Democrats tremendously. I would have been very surprised.
Great. Well, that's a helpful distinction between the institutionalists and the YOLA justices. And let me ask you, how that plays out in the third big case that we're going to...
Jeff, before we get to the third case, there's one thing I'd like to say more about this case, because I think it connects to the themes of the Ideas seminar and indeed the first session, which was about listening to one another. So an interesting thing happened in this case. After I argued it, the North Carolina Supreme Court, where this case was from, changed its mind on some of the key questions. And there were 5 parties on my side versus the Republican Party, and the 5 were a bunch of very liberal groups, as well as the Biden administration, the Solicitor General. And when that decision by the North Carolina court was made, these folks all went to the United States Supreme Court and said, get rid of this case, get rid of Moore versus Harper. It's moot now because the North Carolina court has changed its opinion. And they thought they were going to lose. And we looked at it, and I have such a diverse team of people on my staff, and my method is always to really try and take what the United States Supreme Court says seriously. We live in a kind of soundbite caricature age, and I looked at it, I thought about it, and I said, I think we're going to win the case, and I think that these people are having a knee-jerk reflexive reaction to what the U.S. Supreme Court is about. And so we stood alone. We told the Supreme Court, don't get rid of this case. Decide the case on the merits. And we won. And that, to me, is an illustration of what this week is all about. It's about trying to take each other seriously and listen. And, of course, they're open to all sorts of criticism, and I give it to them, too. But sometimes there's still a space for good results, even when we are opposed to one another.
That's such, bravo, absolutely. It's a hugely important point, and the fact that you persuaded the court to take the institutional view in briefings after the case had been argued is part of this remarkable victory, and it's why Judge Ludig paid you in the case the tribute that he did. Well, the theme of institutionalism is raised by our third case, which is the Alabama voting rights case, the Milligan case. This is one where Chief Justice Roberts and Justice Kavanaugh joined the liberal justices in refusing to strike down Section 2 of the Voting Rights Act, which requires legislatures to be race conscious when there's been evidence of racially polarized voting, and in the process to preserve one of the last parts of the Voting Rights Act that remains available. Pam, you're America's voting rights expert. It's a complicated case, but help us understand it and why it once again reaffirms Chief Justice Roberts' institutionalism.
Sure. So again, a disclaimer, I worked on the case at the Department of Justice. So when President Johnson signed the Voting Rights Act into law in 1965, he said it was the toughest civil rights statute America had ever enacted. And in 1982, the statute was amended to say that states could not use voting practices or procedures that resulted in minority voters having less of an opportunity to participate and to elect candidates of their choice than other voters. So it's a statute not just about the right to participate in elections, but about the ability to elect candidates of your choice. And in large parts of the country, the only way for minority voters to elect candidates of their choice is to have them be a majority of the electorate, because voting is racially polarized in those parts of the country. It's not true everywhere in the United States. It's gone down over time in much of the United States, but there are still places where racial polarization is real, and it determines the outcome of elections. In the 1990s, Alabama was forced to draw one majority black congressional district. It has 7 congressional districts. And it was forced to draw one by the Voting Rights Act. And that district has been redrawn and perpetuated from the 1990s to the 2000s to the 2010 to 2020. And in 2020, Alabama redrew its districts again, creating 1 majority black district and 6 majority white districts. And a variety of different groups brought suit in Alabama saying it was possible to draw a second majority black congressional district, and that the level of racial polarization in Alabama remains high, and that otherwise black voters in Alabama wouldn't have an equal opportunity to participate and to elect. this was a classic case under a 1986 Supreme Court decision called Thornburg against Jingles, which coincidentally was decided the year I was clerking. So my whole life as a voting rights lawyer has been in the Jingles regime. A three-judge district court in Alabama heard evidence in the case. There was a preliminary injunction trial, several weeks of evidence, and said that the Alabama plan likely violated the Voting Rights Act by failing to draw this second majority black district. The three judges who decided the case under the Jingles test, which the Supreme Court has used since 1986 and has been used around the country. And this was really a cookie-cutter case. There was nothing interesting about the case at all, except for one thing. And we've been talking a lot this week about technology. And it was technology that was the interesting thing, which is scientists now have supercomputers that can run hundreds of thousands of simulated elections. They can redraw the districts millions of times and see what the result of the redrawing the districts would be. And it turned out that there were some political scientists who had run, I think, 100,000 simulated maps of Alabama, and they never produced two majority black districts unless they took race into account. And so Alabama said, see, we have a colorblind constitution. You'd have to take race into account too much in order to draw two districts. Therefore, abandon the Jingles test. The case went up to the Supreme Court on the shadow docket, which I think we may talk about a little bit later, and the Supreme Court stayed the order of the three-judge district court in Alabama so that the election in 2022 went forward under the 6 white district, 1 black district, 1 majority black district plan, elected 6 Republicans and 1 Democrat. At the time, the Chief Justice dissented from the granting of the stay by saying, I think the Jingles case decides how this case should come out, but I'm not sure Jingles is right. I think we need to rethink Jingles a little. And so then the Supreme Court heard oral argument, and ultimately the Supreme Court came back and said, no, we're sticking with the Jingles test. This is a case that meets all of the factors under Jingles, and therefore we are sending the case back for more proceedings, and the proceedings are going to be a remedy that will presumably draw 2 districts from which black voters in Alabama can elect candidates of their choice.
Beautifully explained, and it just shows how incredibly significant the case is, and by some accounts it will result in the election of from 3 to 5 more Democratic seats in the next House elections, because this Jingles test, which Pam described, which just to review because it's complicated, requires legislatures to draw districts that where minorities constitute a majority in cases where there's a history of racially polarized block voting and the minority communities are geographically compact and contiguous. That test remains alive. If the other side had won, then there wouldn't be a requirement to create those districts, making it harder for Congress to require that minorities have an equal opportunity to elect representatives of their choice, as they said in passing amendments to the Voting Rights Act of 1982. Clark, just to bring this back to a version of the colorblindness debate, Justice Thomas, in his dissenting opinion in Milligan, said essentially the Constitution is colorblind, and therefore the voting rights amendments violate the Constitution. Congress wasn't allowed to say in 1982 that legislatures have to take race into account to give minorities an opportunity to elect representatives of their choice. And therefore, he would have made it impossible for that to happen. Do I have that right? Explain the consequences of Justice Thomas's strong colorblindness view, and do you think Justice Thomas was right or wrong?
Let me start by saying that I have as much trepidation about talking about voting rights in front of Pam Carlin as I would about pop music in front of Taylor Swift. A bit preposterous, but if you insist, I will say I think you have the characterization right, and I think that the fundamental problem with Justice Thomas's perspective is that it's built on an ipse dixit, which is, in essence, it's an unfounded assertion that the Constitution is in fact colorblind. I'm a hardcore libertarian, and I take equal protection very seriously, as I know we all do. Reasonable people can differ about what that means, but I don't think that it incorporates an absolute requirement of colorblindness, and I think we can think of a number of settings in which that would be extraordinarily problematic. Pam and I were talking about one earlier, which is some prisons are heavily self-segregated along racial lines. There's a whole interesting kind of anthropology about why prison gangs tend to be, they're almost exclusively based on race. And the idea that a prison could never take into account the fact that if you mix some of these prison gangs together, you will have a riot, I think is preposterous. I'm not saying that Justice Thomas would take a different view. In fact, he's written a dissent in which he doesn't embrace that view. But that seems to undercut, to me at least, his categorical assertion that the Constitution is colorblind. So if we reject that, which I do, then we have to have a more thoughtful discussion about to what extent may the government take into consideration racial ethnicity, and to what extent is the government's own history of complicity in disfavoring, and disfavoring, look, that's a euphemism, in, supporting a system of chattel slavery, of enslaving human beings, and then propping up a system of racial apartheid in the wake of the Civil War. The idea that that's not relevant, I think, is also preposterous, and Justice Jackson makes that point in her dissent in the Harvard and UNC cases today. So I think two things are true. I think it's quite clear that the Constitution is not literally colorblind, but then at the same time, it's not a carte blanche. That doesn't mean that the government can just do anything it wants when it comes to race. It's a much more nuanced and a much more challenging opinion. And for nuance and intellectual, analytical virtuosity, I would defer to Pam.
Great. Well, Neil, help us understand this debate between Justice Thomas and Justice Jackson about whether or not the Constitution is colorblind, which plays out in both of these cases. And then what's the significance of Chief Justice Roberts' decision to join the liberals in this voting rights case and the conservatives in the affirmative action case? Does he think the Constitution is always colorblind or not?
So the Alabama case, just the same disclaimer, that's my team's case, so speaking personally and the like. I think Justice Thomas, like today, it's quite remarkable. He says, for example, the Freedmen's Bureau is race neutral. I've read a lot about the Freedmen's Bureau. Nobody I've ever heard of it describe it as race neutral. It was set up after the Civil War to basically protect the freed people, the former slaves. The whole point was it was race conscious. And so there is a race consciousness that was built into the foundations of the 14th Amendment in the 1860s. Of course, Congress was thinking about doing special things for them. We had to. We had an obligation after they had been enslaved for so long. But yet, Justice Thomas is caught between his embrace of history as his method and the fact that history here totally looks the other way. It totally goes the other way. I mean, I was struck, I think Justice Jackson has had a remarkable first term, unlike any other justice in my lifetime at least. As I say, I've been involved in every one of these affirmative action cases for 25 years. I've never heard the point that Justice Jackson made in the affirmative action arguments. She said to the challengers, she said, okay, can I write this essay? I'm applying to the UNC. I'm a fifth-generation North Carolinian. My father went to UNC. My grandfather went to UNC. His father went to UNC. It's really important that I go to UNC. Answer from the challenger, yes. Okay, now can I write this essay? I'm a fifth-generation North Carolinian. My great-grandfather couldn't go to UNC because he was enslaved. My grandfather couldn't go because of Jim Crow, and my father faced the lingering effects of that as well. Can I write that essay? And there wasn't a very strong answer to that, which is why I think you see the Chief Justice bracket that. But someone like Justice Thomas isn't bracketing that. Justice Thomas is saying, nope, race neutrality, race neutrality, race neutrality, wanting to get rid of a lot of the texture and history of this country's relationship to race. And I don't think we can talk about the Alabama case without understanding that this Supreme Court has had a concerted attack on minority voting. And most powerfully, 10 years ago this week, in the Shelby County case, striking down a different provision of the Voting Rights Act than the one Pam was talking about, sections 4 and 5, which is kind of the heart of the act, which said basically, when a jurisdiction that has a history of race discrimination wants to change its voting rules, it had to have pre-clearance from either a judge or from officials in Washington, D.C. And the Chief Justice, in an opinion 10 years ago that I think is one of his gravest mistakes, said that that was unconstitutional, that it treated states differently and violated what he called the equal footing doctrine, and joined by all the conservatives on the court. The equal footing doctrine is a really interesting doctrine because for someone who claims to be a textualist, as these folks do, there is no equal footing doctrine in the Constitution. You can look up, down, and sideways. It isn't there. But it's a made-up doctrine used to basically eliminate this key provision in the Voting Rights Act. And it really does show how far we've gone. I mean, my 46 arguments ago, I guess in 2009, I argued the predecessor case, Northwest Austin versus Holder, in which the court 8-1 upheld that same provision of the Voting Rights Act. And just 4 years later, they strike it down. And so I am very worried about the court on voting. The Alabama case was an extreme case. Those 3 judges that Pam Carlin was talking about, 2 of them were Trump appointees, and yet they found the same problems that Pam identified. It was an easy case. I'm worried about the next one.
Can I just add one thing here, which is about the history? And it is that if you look at what the 14th Amendment says, a lot of people stop after reading Section 1 of the 14th Amendment, which is the Equal Protection Clause and the Due Process Clause, and they never get to Section 5 of the 14th Amendment, which was the section that says Congress shall enforce the provisions of this article. And the reason that provision is there is because the Congress that proposed the 14th Amendment and the people who ratified the 14th Amendment did not trust the Supreme Court to protect the rights of black people, because their experience with the Supreme Court and black people was Dred Scott. And the Voting Rights Act is one of the signature examples of Congress using its Section 5 powers to say, here's how we understand equality to be. And this was not a partisan issue. It was not a partisan issue in 1965. Every one of the extensions and amendments and strengthenings of the Voting Rights Act was signed into law by a Republican president. In the case Neil was talking about, the Northwest Austin case, and then in the Shelby County case, I had the privilege to represent the bipartisan leadership of the House of Representatives in support of the act. And so, politics didn't used to have the kind of racial connotations in the late 20th century that it now seems to be having again, and that's a real problem.
And in fact, in the argument to Northwest Austin, Justice Scalia asked my co-counsel, this act was authorized in 2006 and it was voted for unanimously in the United States Senate, 98-0. And he says, that must have been symbolic. Nothing important passes 98-0. And I'm sitting there in the chair looking at him, and I was like, if I were up there, I could drop the mic and be done with my life as a Supreme Court lawyer, because I would say, Mr. Justice Scalia, your confirmation vote was 98-0.
This is it's a crucial debate that we're having, which we're going to continue tomorrow. But I think Neil helpfully, puts his finger on it when you say that Justice Thomas is caught between the text and history. And as I understand his argument in both the affirmative action and the voting rights cases, he's saying because the text is clear, because the text obviously requires colorblindness, we don't have to look at the messy history, which suggests that in the years before and after the 14th Amendment, there was race consciousness. And it's a version of the argument that he made in the independent state legislature case. Because the word legislature is clear, we just don't have to look at all the history, which suggests that no one ever expected to exclude state courts. Of course, the question of whether the text is clear is the central question in all these cases, and people are fighting wars and filing a lot of briefs contesting the idea that the text is clear. But at least as I understand it, at that point, that's the the difference between the two camps. Well, let's use our remaining time. We'll probably have at least one last intervention. Clark, you are the leading Second Amendment litigator among them in the country, and there's a case on the horizon called Raheny involving domestic violence in the Second Amendment. It comes on the heels of this very significant case called Bruin, where the court just recently struck down New York's concealed carry laws and required a text and history test where you have to find a historical analog for gun control regulation to support it. Justice Breyer said this means that there's now a cottage industry and Second Amendment historians seeing whether or not assault weapons are consistent with the statute of Northumberland of 1393. But tell us about the state of play of the Second Amendment and why Raheny may create further clarity or confusion.
Yeah, thanks. So I think two things are true. I think that the Supreme Court correctly decided the last Second Amendment case that came before it, which challenged New York State's system of deciding who gets to carry a concealed weapon. And they're one of the few states that had what's called a discretionary permitting system. So you had to meet certain objective criterion, but then you also had to go and convince some local bureaucrat that you had a special need to carry a gun. There's no other constitutional right that we only get to exercise if we convince some. Do you really need to have that parade? What are people going to say? Do they really need to hear that? We don't do that in any other area, and the Supreme Court, not surprisingly, said that New York can't do that with respect to deciding who gets to carry a gun outside the home. The reasoning, I think, was quite concerning, because what the court did, I don't want to get too deep down in the weeds, but normally what the court does is it applies a kind of a balancing test. So to go back to a parade permit, for example, can you require somebody to get a parade permit? Yes. But can you charge them $10,000 for it if there's no connection between that and how much it will cost to provide security? No, you cannot. That's the kind of balancing that I'm talking about. That's what the court normally does in most cases where you've got this kind of a right at issue where there are real concerns on both sides, like who's carrying a gun outside the house. What the Supreme Court did in this most recent case called Bruin was it just threw all that out and said, what we'll do is we'll look back at history, and they're not even sure what the relevant time frame is, by the way. It could be 1791 when the Second Amendment was added to the Constitution, or it could be 1868 when the 14th Amendment was added. Who knows? But whatever the time is, we'll look back and we'll see how they were doing things back then. And if the thing that's being challenged today was not a feature of the regulatory landscape back then, and there's no reasonably analogous regulatory scheme back then, you just don't get to do it. I am really flummoxed by this approach. I think for so many reasons, I think it's pragmatically really difficult. I think just even sort of jurisprudentially, it doesn't really make a lot of sense to me. Like, why would we look back at a time, when people were carrying muskets and like shooting wild turkeys, like literally on the way to work because everybody lived in the country. Not everybody, but it was a different time. And of course, there were no high-capacity weapons back then with ammunition that would shoot through three walls. I just, and I am a Second Amendment guy, as you know. I think some of you know. But it just doesn't really make sense to me. So I don't really get this new approach. I also think that a lot, in fact, maybe even most of constitutional adjudication ultimately boils down to line drawing. And just give you an example. How old should you have to be to own a gun? There's nothing in the Constitution about that. I got a 9-year-old son, 8-year-old daughter. I don't think they're old enough. On the other hand, you're eligible to serve in the armed forces when you're 17 years old, and you'll be given a firearm and told to go kill people with it. But then to say to you, oh, but if you're a civilian, no, it's tough. It's a line drawing challenge, and it is a challenge. I just don't see how this, what we now call the text, history, and tradition approach that was announced in this Bruin case helps us do that. In fact, I think it not only doesn't help, but I think it actually clouds the issue and is likely to lead the court into more errors than not. And the last thing I'll say about it is this. There's an astonishing footnote in the majority opinion in Bruin that's also picked up on by Justice Kavanaugh in a concurrence that says, in effect, nothing in the opinion today should cast into doubt the legitimacy of states requiring a license to carry a gun outside the home. Guess what? There was no licensing requirement either at the founding or in 1868. So everything in those opinions calls into question this requirement that half the states now have to get a license before you carry a gun. And to just blithely assert that this new text, history, and tradition approach doesn't call into question the government licensing of who can carry a gun, is absolutely mystifying to me, and I think, frankly, a bit disingenuous.
Can I say something about what the case that's likely to go to the Supreme Court is about? Because it's important for people to realize it.
Do you have to?
I do.
Okay.
I gotta. This is a case that involves a man who was subject to a domestic violence restraining order after he threatened his partner with a weapon. And now he challenges, and he was then convicted for carrying a gun after the restraining order was issued against him. And his position, which succeeded in front of the Federal Court of Appeals, was essentially there were no laws like this in 1868. But do understand that in 1868, domestic violence wasn't a crime, marital rape wasn't a crime. So to say we should look back to those times to figure out whether carrying a weapon today after you've threatened your domestic partner with a weapon is a core constitutional right takes things very far. And the other thing I'll just say about this is one of the things about Supreme Court opinions is justices often join on to stuff that they're not going to stick with the next time around. So it'll be interesting to see how many of the justices who joined the opinion in Bruin peel off when it comes to felons in possession or domestic violence restraining order folks in possession.
We have time for, Neil, you're going to have the last word, but tell our friends what they should expect moving forward. This turned out not to be a simple 6-3 court in every case. We did see Chief Justice Roberts as an institutionalist. How will that play out for the future, and what should we think about the future of the Supreme Court?
Well, the most remarkable thing about this panel is that we've gone an hour and haven't mentioned the word abortion. And that looms over the court. It haunts the court. I suspect will continue to haunt the court in all sorts of very serious ways. What happened in Dobbs last year, I think, was a travesty, and I think very hard to justify from even the court's own premises. And if they can overrule Roe versus Wade, a super precedent like that, then nothing is safe. And that's, I take it, what Pam was saying. So I think this year the court looks very different than it did last year in terms of just the composition of its decisions. Like if you were to ask last year which justices were in the majority the most, it was the Chief Justice and Justice Kavanaugh, 95% of the time in the majority. This time, I only have the data for the first 40 cases decided of the 60, haven't compiled the rest. But of those first 40, Justice Sotomayor was the justice in the majority the most, and it was Alito and Thomas who were in dissent the most. So this is looking like a different term. The question is, will that continue? And, some of those cases are important, but abortion will continue to define what the court's about. So as you look to the next year, you look to the Miffa-Pristone case, that's also my team's case, in which basically a conservative organization shopped for a certain lawsuit in a certain jurisdiction, drew a judge who basically invalidated this abortion drug, which had been around and approved since 2000. And the theory by which the judge allowed that to happen said, well, doctors have legal standing because their patients might take the drug and have some adverse side effect. If that's true, every doctor, my wife's one, is going to have standing for every possible drug because they all have side effects. It's an insane, insane theory. It went up to the United States Supreme Court on this, what we call the shadow docket, not an argument, just an accelerated pace to say, should there be an immediate temporary injunction or preliminary injunction? And the Supreme Court fortunately did the right thing, let the drug continue. But that case is now going to work through the Court of Appeals and come to the United States Supreme Court the next year. And there will be other abortion cases as well. And I think that will be the haunting issue of our time.
Well, thank you for that. And most of all, friends, as you've listened to this remarkably illuminating panel, you have a sense of the need for each of you to read the opinions. You cannot make an informed judgment about whether you agree or disagree with the court unless you take the time to read the majority opinion, read the concurrences, and read the dissents. These opinions are written for you, and if you accept my assignment and pick one of the decisions that we've been talking about, affirmative action, the independent state legislature, voting rights, and read it through, you'll see it's not just written for lawyers, they're written for ordinary citizens, and they allow you to make up your own minds. Most of all, I want to thank my panelists for having educated all of us and provided a model for civil discourse about the U.S. Constitution.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.